In 1882, the US Congress passed a new law requiring the payment of head money, a 50-cent levy per head on every person arriving in the United States by boat. This wasn't a lot of money, about $15 today. However, many of the people arriving in the United States during this great wave of immigration were arriving in poverty. A number of plaintiffs, including the famous Cunard line of passenger ships, challenged the validity of the law imposing head money. A number of arguments were advanced, but one of them was that the imposition of head money would be contrary to treaties made between the United States and a range of European countries, including the United Kingdom, France, Belgium, Prussia, the Netherlands, Sweden, Denmark, and Norway. The treaties were important because the Constitution of the United States includes a provision which states, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and judges in every state shall be bound thereby." Read on its face, this provision makes treaties law and places those treaties on an equal footing with the Constitution and with federal law. Does this mean that international law, or more particularly treaties, are automatically binding as law in the United States? The court said no. The finding of the court was that while treaties were in fact law, the Congress was at liberty to pass contrary laws, and the congressional laws would have supremacy. The court said, "A treaty is primarily a compact between independent nations. It depends for the enforcement of its provisions on the interest and the honour of the governments which are parties to it. If these fail, its infraction becomes the subject of international negotiations and reclamations, so far as the injured party chooses to seek redress, which may in the end be enforced by actual war. So far as a treaty made by the United States with any foreign nation can become the subject of judicial cognizance in the courts of this country, it is subject to such acts as Congress may pass for its enforcement, modification, or repeal." This case confirms, even for countries not bound by this unusual constitutional provision, national law always remains supreme to international law and treaties.